amount of time at the end of the presentation. So getting started today, who is our presenter? The Landegger Verano Law Group and Marie Davis. Landegger Verano has represented employers since 1983. They have long-term relationships, direct result of success in advice and litigation. Their clients know that the best interests are always their top priority. So they provide businesses with legal strategies to avoid employment litigation and cost-effectively resolve disputes. So Marie Davis, prior to joining Landegger, was practiced insurance defense with an emphasis on premises liability. Prior to attending law school, she worked for a nonprofit organization in Central California, helped build low-income housing. Marie learned firsthand some of the struggles facing small businesses and large businesses, and consequently committed herself to helping such organizations overcome their obstacles, particularly in the employment arena. She joined the firm partly due to its philosophy that education is the key to preventing lawsuits in the first place. Marie lives in Central California, Ventura County. She enjoys hiking, going to the beach, volunteering, et cetera, et cetera. So, Marie, if you want to get started there, I can see your screen and everything is fantastic, and feel free to get going.
Thank you so much, Scott, and good morning to everyone who's listening. Today we're going to talk about the federal guidelines for exemption from overtime. And I am in California, and I practice in California, and I know that some of you listening are in California, and many of you are not. But once in a while, I am going to have no choice but to interject as far as California law is concerned, and a number of other states besides California have their own rules when it comes to exemptions. And the Fair Labor Standards Act is the FLSA, which is what you will be seeing up there all the time today, is a lot more lenient when it comes to the definition of exempt employees and a lot more fair to employers. But states like California and a couple of other states in our fine country are much more stringent when it comes to the definition of what makes somebody exempt. And so I do want to caution everyone who's listening that while we're going to talk today about the federal rules, you do want to speak to your employment attorneys that represent you in the state where you are actually conducting business, because those state rules can trump the federal rules. Because the way it works is that if your state rule is more strict than the federal rule, then the stricter state rule will apply. So in order for let's just get started, and I'll interject as I need to. In order for the FLSA to apply, the first step, of course, is that there needs to be an employment relationship. There needs to be an employer and an employee. So obviously it doesn't apply to true circumstances of independent contractor relationships. Now, almost every employee in the United States is covered by the FLSA. And examples of employees who may not be, independent contractors, employees working for small construction companies, licensed subcontractors, or business owners, partners, managing members, that type of thing. Otherwise, if you are a salaried employee making $300,000 a year, or a minimum wage earning employee in Tennessee making, $8 an hour, you're going to be covered by all the same rules for the FLSA. Covered non-exempt employees must receive 1.5 times their regular rate of pay for all hours worked over 40 in a work week. That's the basic rule under the federal guidelines. If you work more than 40 hours a week, you have to earn 1.5 times your regular rate of pay. It's surprising, though, that a lot of people get confused with the term of regular rate of pay. So it's not minimum wage. It's not your hourly rate. It's determined by how much you're earning. It's determined based on your regular rate of hourly pay. So if you're paid $15 an hour, then anything that you work over 40 hours, your overtime rate is going to be $22.50. So it's 1 whole hour plus half. So that's the rate. That's how it's calculated. It's not minimum wage. So for every hour, and it's not the $7.50. These are basic rules that a lot of employers get confused with. It's not earning an additional half rate. It's earning the $22.50, not the $7.50 or the $15, or the minimum wage, which could be as low as $8 an hour. There are, of course, numerous exemptions and exceptions from the minimum wage and or overtime standards of the FLSA, and that's what we are here to talk about today. And the most common FLSA minimum wage and overtime exemptions are often lumped together in this, quote, white-collar exemption. So the white-collar exemptions are those employees that fit into the definition of executive, administrative, professional, outside sales, and computer employees. And so we're going to touch on each of those today. So there are 3 tests for exemption, and this is important because you have to satisfy all 3. You can't just satisfy 1 or 2. It has to be all 3. You have to have a salary basis, a job duties basis, and a minimum salary level, which means you can't just earn, well, we'll talk about it, but you have to earn at least double the minimum wage in certain circumstances, 1 1/2 times the minimum wage in other circumstances. Here in California, it is always double the minimum wage in order to just at all be considered an exempt employee. But you have to meet all of the tests, and that's where people get in trouble a lot of times. And, if you misclassify somebody as an exempt employee, so you're paying someone a straight, and I understand that everybody wants to be a salaried employee, especially the younger employees, the newer generation that's coming into work right now. I've got clients where I've walked into their offices, and they're wonderful places to work. I mean, I would want to work there all the time. They have the stand-up desks. You're allowed to bring your dog to work. They have the kitchen in-house where chefs are making them breakfast, lunch, and dinner. They're given time off they're given salary incentives for riding their bike to work or taking public transportation. They're great places to work, but everybody wants to be considered a salaried employee and have some fancy title like vice president of marketing, when really all they're doing is picking up the phone and making sales calls all day. So I understand the appeal for people to be classified as an exempt employee, and when people are paid on an hourly basis, they get upset or they feel like they've been demoted. But it doesn't matter what they want. Unfortunately, you're on the hook as the employer for misclassification. And if you misclassify an exempt employee, let's say they're making $40,000 a year, and you're having them work roughly 50 hours a week because they're exempt from overtime and they're an exempt employee and you want to treat them that way, well, they're not even keeping track of the hours that they work. So in that scenario, if they ever were to file a lawsuit, which happens all the time, especially in this state, you have no way of proving how many hours they actually worked. And they could just walk into court and say that I worked 50 hours or 60 hours a week as a non-exempt employee who was misclassified. And now for that regular rate of pay, the court, if you lose, is going to take $40,000 a year, divide it by 40 hours a week and 52 weeks, come up with the hourly rate, come up with the overtime rate, and then say you're on the hook for that overtime rate for 10 to 20 hours a week, plus penalties, plus interest, plus attorney fees. So it can really get out of control and add up pretty quick. Now, some of you probably remember this because it wasn't that long ago, that under Obama's administration, he changed the minimum wage from $455 a week for that standard salary level to be considered an exempt employee to $913 a week. So almost double. Well, actually, yeah, it is double. And the highly compensated employee from $100,000 a year to $134,000 a year. So very, very significant increases. And as was expected, several states were upset, saying, hey, we can't do this. This is doubling everyone's income for them to be considered exempt. And so they went to federal court to try to block it. And again, as expected, it was blocked. So currently, you still are in effect with the pre-November 22nd, 2016 rules. So currently, in order to be considered an exempt employee under the FLSA, you need to earn at least $455 a week. And in order to be exempt under the highly compensated employee exemption, you have to be earning at least $100,000. So these new regulations they're not being enforced now because it's still been blocked. So the salary basis test. In order to be an exempt employee, the individual must regularly receive a predetermined amount of compensation each payroll period. The compensation cannot be reduced because of variations in the quality or quantity of work performed, and they need not be paid for any work week when no work is performed. And just so you know, again, this is just federal. Some states say, wait a second, if you don't pay them for any work week, they could potentially lose the exemption. So just be careful and seek counsel on some of these other issues. Deductions. An employee is not paid on a salary basis if deductions from the predetermined salary are made for absences occasioned by the employer or by the operating requirements of the business. So for example, I'm a salaried employee. I fit within the professional exemption. We'll talk about that in a moment. If we're closed on a holiday, if a holiday falls in the middle of the week, and I still get paid the exact same amount of money every single week that I work here, even if we're closed. Because if I don't get paid the exact same amount of money every single week, then I'm no longer considered exempt. That's the whole point of salary basis. You can't make deductions from my pay. If I come in to work, and as I'm sitting in my office right now, I'm doing this webinar, it's 10:15 California time. If I finish the webinar at 11 and decide I want to go to the beach for the rest of the day, my boss will probably be upset, but he cannot deduct my pay. I can be disciplined, but you cannot deduct my pay. I have to earn my entire pay for today and for the entire week. I could take the whole week off and I would still need to make that same amount of money. And so that's also a risk when you have employees that are classified as exempt. Because we get a lot of calls, oh, I have this exempt employee and she's out on, she took 5 hours off today, can I deduct from her pay? No, you can't. The answer is no. Or it's a huge risk. There are certain circumstances when you can, but it's just a huge risk for there to be a variance in what their weekly salary is. So if the employee is ready, willing, and able to work, deductions may not be made for time when work is not available. So it can't be just if you're paying them salary and you've got nothing for them to do and they're going to watch Netflix and YouTube all day, you still have to pay them. Okay, so here are the exceptions. but the rule of thumb is still don't ever do it. So these are exceptions, but there's always exceptions to the exceptions, and hundreds of cases that have been litigated around these exceptions. So I'm going to still tell you don't do it, but these are the limited times when you can. Absence from work for one or more full days for personal reasons. Now, that's what you need to underline. Personal reasons other than sickness or disability. And, usually they're just going to call in sick. Absence from work for one or more full days due to sickness or disability if deductions are made under a bona fide plan, policy, or practice of providing wage replacement benefits for these types of absences. In short, you can deduct from them if they're collecting temporary or long-term disability payments. If they're not, then you can't. You can also offset any amounts received as payment for jury fees, witness fees, or military pay. I mean, as you can see, these are highly limited examples of time. There's penalties imposed in good faith for violating safety rules of major significance, unpaid disciplinary suspension of one or more full days imposed in good faith for violations of written workplace conduct rules. And this one I'd like you to also circle because here in California, and again in other states, when you have an exempt employee, you cannot actually deduct from their pay for disciplinary reasons. There's an entire labor code decision on this that says that no, because if you deduct, even if you're doing it for disciplinary reasons, then they can lose the exemption for that week, and then you're on the hook for wage and hour penalties. So you just want to be careful. Proportionate part of an employee's full salary may be paid for time actually worked in the first and last weeks of employment. That's okay. And unpaid leave taken pursuant to FMLA. That's kind of a given. The effect of improper deductions. An actual practice of making improper deductions from salary will result in the loss of the exemption, which, as I just said, is where you get into a lot of big trouble. But it's the loss of the exemption during the time period in which improper deductions were made for employees in all the same job classifications and working for the same managers responsible for the actual improper deduction. So what that means is that you're opening yourself up to federal class action issues. I mean, it's a big deal, and wage and hour violations, even for 1 month, is such a headache, and your attorney's fees can just get piled up on top of each other. You just really want to be careful. Isolated or inadvertent improper deductions will not result in the loss of exempt status if the employer reimburses the employee. So that's like a safety net that the federal guidelines give you, but again, most states won't. So what does it mean to be considered an exempt employee under the executive exemption? What are the duties? Your primary duty as an executive is the management of the enterprise or of a customarily recognized department or subdivision who customarily and regularly directs the work of 2 or more employees and has the authority to hire or fire other employees, make recommendations as to hiring and firing, advancements, promotion, discipline, and other change of status of other employees that are given significant weight. What does this mean? This means that your assistant manager at McDonald's or your general manager at the Nike store is most likely not going to be considered exempt as an executively exempt employee, because your assistant manager at McDonald's and your general manager at the Nike store are probably spending more than 50% of their time serving customers, stocking inventory, doing paperwork in the back, doing ordering, that type of thing, putting away the stock, making sure that the front of that store looks pretty, whatever. And then maybe 20% of the time, they're actually, quote, managing employees, telling employees to take their breaks, writing up employees for getting an order wrong, whatever it is. That's not considered an executive duty. Executive exempt means that you are in charge of that entire department. You need to be the general manager of the entire region of McDonald's, and you need to be able to come in and say, I don't like what I just saw you do, so you're fired, get out of here. And you don't have to go up the chain of command to get that decision authorized. That's what it means to be an executively exempt employee. And I hope I explained that well enough, but we can talk about more at the end. The executive exemption also includes employees who own at least a bona fide 20% equity interest in the enterprise, are actively engaged in management of the enterprise, and the salary level and salary basis requirements do not apply to those exempt 20% equity owners. So this is just one of these, again, carved out exceptions to the general rule. Administrative, and we're kind of glossing over this somewhat because we could spend an entire webinar on the definition of executive, the definition of administrative, and and beyond. So we're going to make this as simplistic as we possibly can. Administrative duties. The primary duty of somebody who's exempt as an administrative employee is the performance of, quote, I should have quotes there, office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. The primary duty includes the exercise of discretion and independent judgment with respect to those matters of significance. What does this mean? This means that in order to be administratively exempt, you're performing tasks that relate to the business of the business. if I can make it that simple for you. You're there to run a department that helps the business run, but has nothing to do with the primary integral purpose of the business. So for example, if you're in the business of producing widgets, producing and selling widgets, an administratively exempt employee is not going to be on the floor making the widgets, is not going to be putting the widgets in the box and distributing them, is not going to be on the phone with customers or with marketing. Well, no, start that. They will be, marketing is okay. Not going to be on the phone with customers to discuss their orders of the widgets. An administratively exempt employee is going to be in the background helping to run the business. So that is accounting. An administrative exempt employee could be running that accounting department, or marketing, so coming up with plans for advertising and social media and that sort of thing. HR, that's the greatest example and easiest one. If you're an HR employee, you are in charge of all of the personnel, and you can take those skills and knowledge and experience and take that with you to any other company. It doesn't matter if they're in the business of producing widgets or flying airplanes or running a Fortune 500 company. If you're in the HR department, it's the same. You're in the business of running the business. Again, you have to be able to have the exercise of independent judgment and discretion. And that means that you can't have more than like one boss. Really, that's the way I make it easiest for my clients. Everybody has a boss, and certainly there are certain decisions that you have to run by your boss at a certain level. But when you are exercising independent judgment and discretion, that means that your boss tells you, I need a marketing plan developed in 3 weeks. And then you go do it. And your boss has very little say-so in how it is that you made that happen. That's the definition of an exempt employee. If you have 1 or 2 or 3 or 4 bosses, then you're not exempt, basically. Here are all of the, I should have switched the slide a little bit easier. Here is management or general business operations. As I was saying, marketing, research, human resources, labor relations, quality control, advertising, accounting, that sort of thing. Computer network, internet, database administration, your whole IT department would be considered exempt employees under that definition. Insurance claims adjusters, they are exempt. They may be, well, 90% of the time they're exempt. Their duties must include interviewing the insured, witnesses and physicians, inspecting property damage, reviewing factual information to prepare damage estimates, evaluating and making recommendations regarding coverage of claims, determining liability and total value of claims, negotiating settlements, and making recommendations regarding litigation. So basically everything, if any of you have dealt with insurance claims adjusters, I mean attorneys like myself, we deal with it all the time, they're considered exempt. Financial services, if you're in the financial services business, you are probably exempt under the under this exemption. If you are involved in collecting and analyzing information regarding customers' income, determining which financial products best meet the customer's needs, advising the customer regarding the advantages and disadvantages of the products, and marketing, servicing, or promoting the employer's financial products. So what is that? These are your mortgage brokers and lenders, your bank, vice president, even though everybody has the title of vice president in a bank, it seems like, but the one of lending, the vice president of lending, the loan director for some of these financial entities. And an employee whose primary duty is selling financial products does not qualify for the exemption because they're not, if you look ahead, actually determining, analyzing income and assets, putting everything into their program, reviewing credit, evaluating the best program, the best lending program and option for their customers. If all they're doing is selling the product, then they're a rank and file employee. Okay, this is the easiest one, professional. The professional exemption is somebody who is exempt based on their learning, skills, and experience. The primary duty of a professionally exempt employee is the performance of work requiring knowledge of an advanced type in a field of science or learning customarily acquired by a prolonged course of specialized intellectual instruction. And the primary duty could also be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So, in layman's terms, if you are a doctor, a lawyer, a psychiatrist, a CPA, a tax enrolled agent, if you're somebody who has had to go to school for more than just a bachelor's degree and you are given work based on your own knowledge and skills and advice and learning, then you're going to be considered an exempt professional. And in most codes, like here in California, the labor code specifically says doctors and lawyers are examples of people who are exempt. Teachers are also exempt. The other exemption of primary duty is the performance of work requiring invention, imagination, originality, or talent in the recognized field of artistic or creative endeavors. Well, yeah, so your artists, your music performers, your movie directors, your art directors, that type of field is also considered exempt because you're being hired for your own creativity. And so clearly you're being hired for you're exercising independent judgment and discretion, and therefore you fall within the exemption. Field of science or learning, like I just said, law, accounting, teaching, engineering, chemical, physical sciences. And then the exempt medical professions, doctors, nurses, medical technologists, dental hygienists, and certified physician assistants. Now again, this is all great under the FLSA, but have to caution you about what happens in individual states, because individual states can say that these people are exempt, or do not fit within the exemption just based on their certain protocols. Lawyers, teachers, accountants, pharmacists, engineers, chefs, certified athletic trainers. I kind of think that one's funny. But licensed funeral directors or embalmers, I guess, again, they have a specialized field of study and learning, and they're certainly exercising independent judgment and discretion. So, you know, as you can see, it's pretty far-reaching, and it's my favorite one because it's the easiest one to get a pass on. Additional non-exempt professions. See, this is where you have to be careful. Licensed practical nurses, accounting clerks. Oh, good. This is non-exempt professionals. That's what I was going to say. This is the non-exempt ones: licensed nurses, accounting clerks, cooks who perform routinely manual, mechanical, or physical. Paralegals are not exempt. Engineering technicians. You just have to be careful. Recognized field of artistic or creative endeavor, as I was explaining: musicians, writers, actors, graphic artists, set directors, photographers, cartoonists, screenplay writers. And you get the idea. The next exemption is the computer-related occupation exemption. This is separate from your IT department. Your IT department is exempt under the administrative exemption. This is something different. This is the computer expert exemption who actually writes programs, writes code, develops software, and is a little bit more involved in the inner workings of the computer, not just your networking system. So their primary duties: the application of systems analysis techniques and procedures, including consulting with users to determine hardware, software, or other system functional specifications, and design and development of those specifications, and the design and development and testing and creation of the apps and the operating systems and anything related to computer and software. And the employee must also receive either, and as you notice, this is double, this is actually current, so they must earn a guaranteed salary of $913 per week or an hourly rate of not less than $27.63 per hour. This is current, so if in fact the 2016 rules change and it's $913 per week for everyone else, then logic would dictate that now the computer-related exemption occupation individuals would have to earn $1,826 a week in order to be considered exempt, so double the minimum. Outside sales. Now, this is, again, one of my favorite ones here in California because outside sales individuals are the only people that can actually bring home a zero paycheck. But there are all of these rules that go along with what really makes somebody an outside salesman. So the primary duty, of course, is making sales or obtaining orders or contracts for services or facilities for consideration paid by the customer, and who customarily and regularly is engaged away from the employer's business in performing sales duties. And like I just said, there's no compensation test because an outside salesperson could have a zero paycheck. Now, in California, they make it even more stringent and say you have to spend more than half your time outside of the office engaged in these sales activities. Then there's literally hundreds of cases saying, well, what makes up sales activity? So if you are a water delivery man, for example, you have a truck full of water bottles and you have to make deliveries to homes and offices. You're clearly spending more than 50% of your time outside the office, but you're delivering water. So there's been about 4 or 5 cases just based on water delivery guys on whether or not there can be considered outside salesmen or non-exempt delivery people. And what the courts, make their rulings based on is delivering water part of a sales activity when the act of actually delivering the water means that the delivery man engages in communications with the customer in trying to sell more services. And in fact, under the federal guidelines, that's considered, delivering the water is considered part of a sales activity, so they are outside salesmen. But in individual states, like here in California, no. If an individual is spending 80% of their time delivering water and only 20% of their time actually selling the product or in trying to enhance the service, here in California you lose and you're just a delivery guy. So we got to be careful. An outside salesperson can have a zero paycheck. It's wonderful. It's great for you. Kick them out of the office. Make sure that they're out there actually selling your product or selling your service and that you're paying them on a commission for when they actually pull through. I have a current case right now where an individual should absolutely 100% be outside sales, and the job dictates it, the job description dictates it. The whole business of my client is selling a very specific product, and they're very successful at it. That is what he was hired to do. That is what he should have done. What's the problem? The problem is that he spent the entire time that he worked there, which was about 6 months, working in the office. Why did he do that? Because my client has one of those really great offices that I was talking about earlier where they have personal chefs and you can bring your dog to work and all that stuff. So he thought it was really cool just to hang out in the office all day. And he never made a single sale, which is probably not a surprise to anyone. But now I'm stuck in a position of how do I make this guy an outside salesperson, make him exempt when one of the key parts of the exemption is that you have to get the hell out of the office. So if you have any outside salespeople, you really do need to make sure that they are not in the office because that will completely destroy the exemption. Okay, here's another one, an exception for, and the FLSA, the federal regs call it the Retail Commission Sales Employee, and in California it's known as inside sales. So somewhat similar. You might think of them as telemarketers, but for the FLSA, it's retail commission sales employees. They are employees of a retail or service establishment who are paid more than half of their total earnings on a commission basis, and they will be exempt from the overtime pay requirements of the FLSA. They must be employed by the retail or service establishment. More than half of their total earnings must represent commissions on goods or services, and that means that they cannot actually perform the service, because that's a big trap that a lot of employers get into. If you're earning a commission is based on the sale of a service or the sale of a product. It's not based on actually performing the service. For example, for a long time, I mean, actually, hairdressers have been paid on a quote commission basis. They get 40% of whatever haircut they perform, whatever hair dye job they perform. That's how they're paid. And unfortunately, that's completely wrong, because that's not a commission. They're actually working on something called a piece rate basis, because when you cut somebody's hair, you're performing the service, therefore you're not selling the service, so you're not really earning a true commission, because that's what the definition of commission is. So as long as they're earning more than half of their salary based on commissions, for true commissions for sales of goods or services, and the employee's total commission compensation divided by the number of hours worked must exceed more than 1 1/2 times the minimum wage. So for outside sales, it's like one of the most complicated formulas. I mean, excuse me, inside sales, it's one of the most complicated formulas, because if you work 40 hours, well, no, if you work 50 hours, that's always easier, your earnings of commission for that week, for those 50 hours, first has to come, half of it has to come from commission. The other half can come from a salary, but if you add up your salary and your total hours worked, it has to still exceed 1.5 times the minimum wage. And I know it's a little bit confusing. If you guys have questions, I can email you examples. Unless all three conditions are met, the exception does not apply, and the overtime premium must be paid for all hours worked over 40. So here in California, it even gets worse, because they still are entitled to meal and rest breaks. They have to keep track of all hours worked, blah, blah, blah. It's not really, they have to get paid overtime for, if you screw it up, they have to get paid overtime for working more than 8 hours in a day, not just 40 hours in a week. So there's lots of things to take into consideration. Common errors to avoid: assuming, of course, that all employees paid on a salary are not due overtime, improperly applying an exemption, failing to pay for all hours worked, that is, quote, suffered or permitted to work. If you have an employee that's on your premises, it doesn't matter what they're doing. They're your employee, and you need to be paying them. So, find them something to do, or pay them for sitting in the chair and watching Netflix. Also limiting the number of hours employees are allowed to record. Now again, if you have an exempt employee, why would you make them keep track of your hours? The problem is that you need to make sure that you've properly classified them as exempt, because if you get into a lawsuit situation and you don't have any record of how many hours they worked, then they're the ones that get to say, oh, I was working 50, 60 hours a week, and they never paid me overtime, and I was only making $40,000 a year, and they were taking advantage of me, and that's the kind of cases that we're left with. Of course, failing to include all pay required to be included in calculating their regular rate. So that's because your regular rate is not just your salary, it's not just your hourly rate, it includes your commissions, it includes guaranteed bonuses, not discretionary bonuses, but it includes all those things. Making improper deductions, you definitely don't want to do that. Treating an employee as an independent contractor, that's a whole other webinar that we've done for NovaTime, and we'll probably have to do again sometime soon. And then, of course, as I've said about 5 times during the presentation this morning, confusing federal law and state law. Federal law is very lenient, and state law, in some cases, is not. And so you want to go with whichever law is more, it's harder on the and more fair to the employee. If it's stricter rules, you got to follow the stricter rules. You know, sometimes even city laws will trump state laws. Like, again, here in California, we have a state law that allows for 3 days of paid sick time. Well, if you work in the city of Los Angeles, you actually get 6 days of paid sick time. So you want to keep all of those issues in mind. What does the FLSA not require, which is great for everybody who's not working in California? The FLSA does not require vacation, holiday, severance, or sick pay. Also does not require meal or rest periods, paid holidays, premium paid for weekends. It does not require a discharge notice, reason for discharge, immediate payment of final wages, terminated employees. Here in California, that's a 30-day penalty that you could be on the hook for. The FLSA does not require any limit on the number of hours in a day. Like I said, you can work 16 hours in a day and not be paid overtime under the FLSA. It's all about your weekly overtime, whereas here in California, if you work more than 8 hours, it's time and a half. If you work over 12 hours, it's double time. The FLSA also doesn't require pay raises or fringe benefits and that sort of thing. So what happens if you violate any of these rules? Well, your biggest problem is a lawsuit. Your biggest problem is a federal class action, because that's going to be what, that's where the real money comes in, and that's where it gets super expensive in attorney's fees. Your next problem that you want to be concerned about is a single plaintiff wage and hour case, because still, if you're facing a civil lawsuit for failure to properly classify your exempt employees, you're looking at as far back as 3 years of unpaid overtime. And if you don't have those records, then, you know, the court could very well just take the employee's word for it. So those are the 2 things that you most are going to be worried about. But people can make an independent claim, employees can make an independent claim through the Department of Labor. So the FLSA enforcements are carried out by the wage and hour staff. When violations are found, the wage and hour staff of the DOL advises employers of steps needed to correct, secures agreement to comply, and then supervises voluntary payment of back wages, which can be substantial. I have done a couple of these DOL audits, and it is crazy how fast the penalties can stack up. 2-year statute of limitations generally applies to the recovery of back pay, but in the case of a willful violation, a 3-year statute of limitations will apply. And if you've misclassified, they absolutely consider that willful. In the event there is not a voluntary agreement to comply, the Wage and Hour Division may bring the suit on its own. Now you've got the government involved in the lawsuit, and they really are not looking out for you at all. And they can also bring suit for back wages, which is an equal amount to whatever it is that, to the violation that you had, and then double it. So let's say you're on the hook for $10,000. That's a really low number. They can bring another claim as liquidated damages for an equal amount of that. So you're getting penalized double. So $20,000 instead of $10,000. And then, of course, the employee may, as I just said, file a private suit for back pay and an equal amount of liquidated damages plus really expensive attorney's fees like court costs. Penalties from the DOL and employers who willfully violate the Act may be prosecuted criminally and fined up to $10,000. Civil penalties and others. I mean, if you're really interested, you can go to that link. And